Hi, everyone. Thanks again for attending this webinar today, which is the first in a series of webinars this month focusing on sales and acquisitions in the social care sector. My name's Lisa Davison. I'm a partner in the real estate team at Hamptons. I'm a specialist corporate healthcare property lawyer, and I predominantly deal with sales acquisitions, leases and funding for health and social care clients. So that's everyone from GPs, dentists, charities and to social care providers. And I am joined today by James Butcher, who is a senior solicitor in our corporate team. And James deals with the same types of clients as I do, but he works on the corporate side. So we've got property and corporate expertise today. Now, the nature of these type of deals is we'll often need a variety of legal specialists. So generally the likes of James and myself will be the core legal team in these type of transactions, but we'd also usually need expertise from other specialists. In Hamptons, we have the charities team, employment team, the regulatory CQC team, and amongst others. So there's a range of expertise there, and some of the experts, the specialists, will be joining on the other webinars later this month. Excuse me. So the first session will be an overview of sales and purchases. There's lots to think about. So on the next slide, I'll just break that down with what we're going to look at. And there may be some elements as well that we touch on, which is going to be covered by the following sessions. So don't be worried if we don't go into too much detail on those sessions, particularly on charities and the employment, which will be the focus of the follow-up sessions. So looking at the session outline then for today, what we've done to try and make it easier and clearer and to visualize what we're talking about, we've split it into three main sections here. So we've got the pre-legal section, legals and post-legals. We're going to focus quite a bit of time today on the pre-legal side, so some things that you can be doing and thinking about before we even get to the legal stage. Firstly, to make James and I's jobs easier and to make the process a bit smoother as well. So that's looking at various options before you even come to sell or buy social care property. Look at the different structure, and that's both on the corporate and the property side of how these transactions are typically structured and some of the things to think about when looking at structure. We'll touch on heads of terms and some of the things that we might want to be thinking about. Due diligence, and this due diligence focus is really things to think about before the legal stage here. What can you be doing to help that process along? And then finishing that section there just with a brief outline of regulatory compliance. And then we will turn to the legal process itself. So that's when James and I will get involved. We'll look at a process overview and completion. We'll talk about how long typically those processes take, and again, how we work with other professionals to make that as smooth as possible. And then it doesn't end there. There'll be post-legal bits and bobs to deal with. So there may be points to consider on deferred consideration and earn-out provisions, which James will talk about. Any future involvement you may want or may not wish to have with the business. And then I'm just going to finish off there with a quick discussion on overage, what it is, and how that might fit into some of these negotiations. And then we'll just finish off with some takeaway top tips there based on our experience, some points to take home there. So we will, if we go on to the next slide, we will look at the pre-legal section here. So again, this is things you can do before you instruct your professional team to ensure that you're prepared. And I guess the key is here, the more you do at this stage, the easier the next two stages will be. So first of all, before we do anything, we want to consider our options. We want to be open-minded when we come to buying and selling. Look at our options on the market. do we want to sell the property and the business as a going concern, or do we want to look at some alternative uses? And I guess the key is here to speak with a surveyor and see what options are available. A lot of these points here are linked and will form part of those initial discussions. So part of those discussions will involve you obtaining evaluation of the property, both as a going concern and just as the property as it is, just so we can consider those elements. We may want to look at what improvements we can make before we even go to the market, to the property, to the business. So, whether that's looking at, things like looking at extensions, looking at, I guess, or just even a fresh lick of paint, better use of space, that type of thing as well, just to make it all a bit more attractive. Looking at demand in the local area as well, so we know and can take advice on what the likely demand is for that type of property, both as a going concern and not. I have a client, for instance, who has a very specialist rehabilitation centre. There's not many of them for targeting the particular clientele as they do, and people do come far and wide for that particular facility. So there's a higher demand for that type of property than perhaps a standard residential care home. So demand will play a factor there as well. Again, I talk about alternative uses. Some things to be guided from the surveyors here. And also a key here really when you're considering alternative uses is perhaps to look at previous uses of the site, because although it may be used as a care facility at the moment, looking back at the planning history will give you some idea of types of uses it could be used for going forwards, and perhaps give some options there. And then when buying, obviously look at any development opportunities, we're not just perhaps looking at existing care facilities. There may be, you may want to look at vacant land, you may want to look at land already in use. And actually I read in our local paper the other day that a care provider obtained planning permission on a local site to where I am in the Midlands, which is currently used, it was used as a cinema, so it's on a leisure complex, and planning permission has just been obtained on that particular site. So obviously you've got your car park in there already, the space, you're not too close to local residents usually, so there was less objection from the local residents to that use, and that's something. And I've also had shopping centres as well form part of these planning applications, so it's just being open-minded to the different development opportunities as well. And that leads nicely on to the final thing to think about here, which is your funding options, depending on whether you're buying as a going concern or whether you're looking at development opportunities. Funding is going to play a big part in that. And then obviously when selling as well, we need to think about what we need to do to discharge any existing funding arrangements which may or may not be in place, and how that may come into play in terms of timescales, etc. So next we will go on to the structure. We'll look at corporate structure and property. So James will just talk us through how the corporate structure may work first.
Thanks, Lisa. So yes, depending on how assets are held, you may decide either you want to purchase specific assets in the business, or you may want to purchase it as a package. So there on the screen is really a brief description of the two different types of acquisitions you may want to consider. An analogy of those would be to think of it as a chocolate box. So if it's a share purchase, you need to think that you're taking everything that comes with that business. So with the shares, you've got the liabilities, you've got the assets, the equipment, the staff, everything all packaged nice and neatly with all the chocolates there. If you're looking to purchase specific assets in the business, then really you rip the top off and you think, right, I want this, this, and this, and you take those and extract those out. It's not as simple as that, obviously, because there may be liabilities attached to those assets, but as we'll go on to the forthcoming slides, we can address those. Thank you.
Okay, so turning to the property structure. So we may have to deal with the property differently depending on whether we're dealing with we've got a share deal or an asset deal, as James said. But other factors which may come into play is whether the property is freehold or leasehold. So freehold property is obviously where the property is owned outright and there is a capital value there. Leasehold may be a long leasehold interest where there would be a capital value also, but may also be subject to what we call a rack rent lease, so a shorter term lease with a rental liability, and no doubt tenant covenants and a landlord to deal with as part of that process as well. So that may govern the procedure for sale. And when we're dealing with a share purchase, a share sale, as James mentioned, when we're buying the whole of the assets, that will include the property as well. So in some respects, when we're dealing with a share deal on the property side, things are a little bit easier. We're simply doing a due diligence exercise, and actually, because we're selling or buying the shares in a company which holds the property, whether that's freehold or leasehold, that asset automatically comes over as well. So it's more about due diligence in that scenario. If we're dealing with an asset deal and we need to transfer that property over, so freehold, there'll obviously be a transfer there to a buyer. There may be SDLT implications because of that, so there will be tax implications. And the same with the lease. We're transferring a lease interest. We'll have to get a third-party landlord involved in that process. And again, by doing that, we're adding another party and no doubt another firm of lawyers into the mix as well, which can take time and delay matters and obviously add to the cost as well. So structure is very important to consider at the outset, so we know what we're dealing with and how we factor that into the timescales there. And then just some other bits to think about on the property side. So it's just looking as to whether that property is going to be held by an individual in their personal capacity or by some type of corporate entity, which may or may not be a charity, which will be covered obviously in some of the follow-up sessions. There'll be more detail there because there's more hoops to jump through with charities. And again, that may be driven by tax considerations, but generally most of the property we deal with, there is some type of corporate entity which is involved, even if it's just a shell company, a new company which is holding or going to be buying these assets. That's usually the common factor there. And then lastly, again, we talked about funding. We need to understand the requirements of any lender and any security required by that lender. So where we have a capital asset, where we have a freehold property or a long leasehold property, and you're obtaining funding, say high street funding for a particular purchase, the lender may have security requirements. They're likely to want to have a legal charge over the property. They may or may not want personal guarantees. So those factors will come into play. And then likewise on the leasehold side, if there is a lease involved in this type of transaction and there is some external funding, generally to purchase the business side of things, because the lease is likely to be a rental liability, then the funder may require us to mirror any lease with any funding terms. So the term of the loan, making sure that the payments of the funding are covered by the terms of the lease. So they'd want to be involved in that process as well. So that's all things we think about at the outset when we're looking at the structure. And we often get involved at an early stage in speaking to clients about how these things are going to be structured. And also when it comes to heads of term stage, getting us involved there so we can think about some of these issues, which leads us nicely onto the next slide where we talk about heads of terms. And I'll pass over to James again.
Yeah, so Lisa talked about structure and the structure of the deal, and it's really important to get that set out before you even enter into the due diligence phase or the legal documents phase. So most of you, if not all, have probably come across heads of terms, sometimes obviously referred to a letter of intent or a memorandum of understanding. And really, in most cases, it's the most important document to prepare prior to the commencement, as I said, of the due diligence and the legal documents. So it's important to be aware that heads of terms precede any substantive contract negotiations, and generally they provide an outline of the commercial deal that's been arranged or agreed between the parties. So one advantage of having heads of terms is to focus the parties on key issues which may result in the transaction being concluded in a more timely manner, and also to potentially save costs. I would point out, though, that heads of terms may contain binding and non-binding contractual terms, some of which we'll touch on briefly. So the fundamental terms of a transaction might seem pretty obvious, but it's absolutely paramount. So generally, who are the parties, who's contracting with who's the seller, who's the buyer? That could be a company, it could be an individual. Obviously, we need to set out what has been sold. So what's the purchase price? What is the targets? What is a buyer acquiring? And how is the purchase price to be paid? Again, we'll touch on that briefly. So details of how the party will conduct their due diligence, moving on to due diligence, are typically outlined, which include who is actually permitted to carry out that due diligence for a prospective buyer. So that could be their agent, so a solicitor, an accountant, and it needs to be made absolutely clear who would have access to that information. The heads of terms may also contain details of any proposed restrictions. So, for example, there could be a restriction on the seller once they've entered into the heads of terms not to dispose of a part or a material part of that business. There are also indemnities for any known liabilities at the start of the transaction. It's more prevalent in share purchases, as there will be usually an indemnity for tax, so a tax covenant. But that being said, details of any specific indemnities will usually be negotiated following the due diligence exercise. So move on to exclusivity. So it's generally perceived as a buyer protection, and it means that once the parties have both signed the heads of terms, the seller shall, for a fixed period of time, which is up for negotiation, will not entertain or negotiate with any other prospective purchasers. Generally, a buyer will want a longer exclusivity period, obviously to carry out due diligence, negotiate the legal documents, etc. And typically a seller will want a shorter period. Confidentiality is really important. It's one that we always expect to see in heads of terms. So again, it's important to include it. So that the information which is disclosed is contained between the parties who are in the negotiation, because there's generally sensitive information and legal know-how that goes between the parties. Cost contributions. Generally, heads of terms will have a standard clause in there, in which case each party will be responsible for their own costs. Not all parties want that. Typically, buyers will invest a lot more time and money in investigating the company. So they would want a level of cost protection. Should something come out of the woodwork and having spent X amount of money, feel that it's not worth pursuing the purchase any longer. Timetable. So generally, heads of terms will set out a timetable, depending on the type of acquisition, whether it be an asset purchase or a share purchase, the parties involved, whether or not there's funding involved will dictate the timetable. More importantly, CQC, as we all know, that can take quite a significant amount of time. So generally, if there's a timeline, set out in the heads of terms, it gives the parties something to really aim for, so a target completion date. Very briefly on disputes and governing law, I don't think I've ever had to exercise this at all, but should a dispute ever arise, obviously the parties will want to make sure that the dispute provision isn't there, so that if a dispute arises, they can dispute that in the country of jurisdiction. So if the parties are contracting in the UK, they'll want to ensure that any dispute is argued in the courts of England or Wales. And moving briefly on to property, Lisa.
Yeah, I'll just finish with property. And actually, property is just generally a very small part of these heads of terms, and perhaps doesn't contain as much detail as we would like to see in heads of terms sometimes. But nevertheless, we need to cover it in heads of terms. We need to understand if the property we are selling or acquiring is freehold and leasehold. If it's freehold, quite simply, we just need to know the value which we are attributing to the premises. It's often the most valuable asset as part of any sale, but also can be a large liability. So we need to make sure that that's covered adequately in heads of terms. If it's a lease, we want to see the basic terms of those lease. And again, if there's a funder, we need to make sure that's been consulted with them. So they may have minimum requirements, like I mentioned previously, to mirror the term of a loan, annual rent reviews, that type of thing that needs to be covered there. It's really good actually to know at this stage, and perhaps to highlight in any heads of terms whether there are any third party consents required, so we know whether there are, like I said, any other lawyers involved, particularly where we're dealing with a landlord. It's good to have all their details at this stage as well. More often than not, these parties are engaged a bit later in the day, which causes delay down the line. So if we've got all this detail in the heads of terms, it makes everybody's job a bit easier, and we've got one document with all the legal parties in there as well. And 2 points actually I wanted to just point out with heads of terms when it comes to property, and perhaps something that's often forgotten about, which can have big consequences actually. The first one is in respect of the condition of the property. We want to make sure it's absolutely clear, and particularly, as James says, tied in with some of this cost contribution, that we're able as buyer to undertake a, if necessary, a full structural survey of the property. And if there are any elements of disrepair, there may need to be discussions which come to play in terms of the purchase price itself, or that link into this cost contribution we talked about, depending on any works that need done. Because what may seem okay to the visible eye, to you and I, a surveyor might look around and I've had the case before where a surveyor wasn't instructed, and a client came to us and said, actually, we've got a real big problem. We didn't realise until we got in that all the electrics are not worth anything and the whole thing needs rewiring. The cost of those electrics was more than the rent payable. In this instance, it was a lease, and the client wished they'd undertaken the survey at the outset. So just make sure that's really clear at heads of terms stage, that the buyer wants to be undertaking a survey, and some of these points may need to be revisited. And the other question that we always need to ask at this stage, which sometimes isn't asked, is when it comes to VAT. So we need to understand whether the seller is registered for VAT and whether the property is opted to tax. If it is, that may affect the purchase price, particularly if you're unable to recover, you're not registered for VAT and unable to recover the VAT element. And also, if you're buying a property freehold and you're paying VAT on top of it, your SDLT liability will also go up as well. You'll be paying tax on tax, essentially. Sometimes this question doesn't come out to the legal due diligence stage, and by then it's often, not too late. We can go back and have those discussions, but it's not great for a buyer to discover that halfway through the legal process. People just naturally assume that properties aren't subject to VAT, which, although is the standard case generally with commercial properties of this type. There may be instances where the seller has opted to tax, particularly if there's a new build involved and the owners wanted to recover the VAT elements. You'll often find that there may be VAT payable in those instances. So that's something we really need to find out at that early stage as well. So they're two really important things actually on the property side that's sometimes not thought of at this stage, which actually pays dividends if we do address those and talk about those things at this stage before it goes into legal hands. Next slide, and we start looking at due diligence. I'll pass over to James for this one.
Thanks. So great. Okay, so you've got heads of terms signed. So the next stage is due diligence. So really, it's an opportunity for the buyer to look through the business, identify any potential risks and weaknesses, but equally, I think it's a little bit understated sometimes, but it's also an opportunity for a seller to also assess and take stock of what it is that they actually have as well. So starting really with finances, it's an opportunity to look at the current state of obviously the operating costs, what's coming in, what's going out, and typically we always suggest, if they hadn't already, to instruct a specialist accountant, an expert, to help you go through the accounts and understand exactly what's there. Are there any potential issues in the current account, financial statements, and tax returns? Effectively, the outcome of the financial due diligence will have an impact on the way that we draft and prepare the legal transfer documents, which will obviously include warranties and indemnities, as well as tax covenants. So depending on whether you're buying shares, if you're purchasing the entire issued share capital or the assets of a company, employees obviously are an important part. One thing to note is, obviously, if you're buying the shares in the company, the employees stay in that company, so there's no QP process to go through. However, if you're purchasing the assets and the employees come with that, then obviously you'll have to go through a QP process, in which case you may want to take advice from an employment lawyer to help you guide you through that process and the consultation process. Insurance is really big, more so in care homes than I've seen in other areas. Has the business maintained an effective, sufficient level and adequate amount of insurance? So this could be employers' liability insurance, public liability insurance, professional indemnity. It could also extend to product liability insurance, so things that the home owns, that the residents use. Equally, if you're buying shares in the company, have the directors taken out officers' liability insurance. So really need to make sure that insurance has been in place prior to and up to completion, in case any claims do come out of the woodwork. Commercial contracts, depending obviously whether you're buying the assets or shares in the company, it won't really affect the way in which commercial contracts are dealt with. There's typically assignment and novation provisions contained in commercial contracts. So if you're purchasing the assets and you decide that you want X and Y contracts, but you don't want Z, you could take X and Y contracts, provided that those agreements allow you to do so. Equally, if you're purchasing shares, the entire issue share capital of a company, you'd have to ensure that the change of control provisions allow you to take those contracts on. Usually, if there's a majority of shares that have been purchased and you're taking a majority interest, usually those provisions will apply. Now, the residence contracts, I think this is probably a session in of itself, so I'll only touch on this very briefly. But does the residency contract do what it says it does? Does it cover the amount for? Does it account for receiving payments from the local authority? Does it account for CHC payments? Does it account for aftercare payments? So under Section 117 of the Mental Health Care Act. And does it comply with the CMA guidance, so the Competition and Markets Authority guidance? Is it transparent? Are there provisions in there in the event that money goes, that fees aren't paid? Is there a way to collect that money, and are the residents aware of that? Equipment. Very quickly, what equipment does the business own? Is there anything that's excluded from the purchase or sale? Is the equipment in good pairing condition? Is it subject to hire purchase contracts, for instance? So ensuring that the equipment is in good condition and no further expenditure is required is really key. Finally, litigation. Are there any ongoing issues? So are there issues with CQC or regulatory bodies, for instance? If there are, the seller will need to obviously outline that to you during the due diligence process, and whether or not that is a negotiating point for a buyer or a seller to potentially increase or decrease the purchase price, or if there's a liability which will rear its head in the future. Is that a negotiating point for a buyer to potentially put a sum of money in escrow, for example, to deal with any potential claims that come out in the future?
And then finally, just on property, again, there'll obviously be the legal property due diligence, which we will deal with when everything enters the legal process. But at this stage, the things you can be doing to help in gathering this information as soon as possible, if you're a seller, preparing this information as soon as possible, is the survey I talked about. Let's get the survey instructed as soon as possible so we know what we're dealing with and any issues we may need to address in the legal documentation, or otherwise conduct a site visit, check the plans, and if we have them, the legal plans, so we can see if there's any discrepancies there. Is there anything on site that the lawyers need to be aware of? Is there a septic tank? Does there look to be alternative access anywhere? Any boundaries that perhaps need to be looked at? All those things can be valuable and highlighted to the lawyers at an early stage. And then the big one really for this stage is to look at the regulatory compliance, the statutory compliance documents. So we're talking things here like EPCs, energy performance certificates, the sellers making sure we have those. They generally last 10 years, so we just need to make sure that that's up to date. Any statutory assessments are up to date, and any remedial actions are carried out in all those assessments. So there I'm talking about fire risk assessments, asbestos assessments, Legionellas, boiler service, electric and gas safety certificates, anything there highlighted, lawyers are going to pick up once it gets into the legal due diligence stage. And in nearly every sale and purchase we do come across remedial actions or documents missing, and that's all things that need to be addressed before it gets in the legal documentation. So we need to make sure, if we can, that's all done, collected, all remedial actions are dealt with, and then it avoids having to deal with that at the legal stage and address it in the legal documentation by way of indemnities, positive obligations. There's different ways of dealing with outstanding obligations, but the more we can collect at this stage, the more remedial actions we can carry out as sellers, the less problematic that's all going to be down the line. So that's just a quick summary of the property due diligence at this stage, and then that takes us nicely on to the general regulatory compliance, which we cover on this slide.
Yeah, so very briefly, all care homeowners must be registered as a care provider with the CQC, so the Quality Care Commission, as well as having an appointed care manager. So the CQC review assessment states currently that it can take anywhere between 8 and 10 weeks. However, from certainly my experience and probably Lisa's experience as well, it's way in excess of that. Typically, we're seeing around about 16 weeks. I think in one of the worst cases, not too sure about you, Lisa, but I've had one client who had to wait up to 6 months to receive the registration from the CQC. So it's really important to start that process right from the outset of the transaction. Certainly, it is a legal requirement to register with the CQC. So failing to do so may mean that you're committing a criminal offence, which could result in an unlimited fine, penalties, and I believe up to about 12 months imprisonment.
Not good.
No.
Okay, and then we just have details here of our social care advice line and our CQC resources page. We obviously have specialists at Hempsons in this area. Philippa in particular, probably most of you know, and there's not a lot of training in this area. So there's generally other webinars and sessions available for CQC if you need it as well. And then that takes us on to legals. So we're over halfway through the session today, and we're just coming to touch up onto legals now. So as I said, most of the session was looking at the pre-legals really, and what you can be doing at an early stage before we just touch on the legal process. And we'll try and keep this as simple as possible, because I appreciate once it goes into legal hands, everything's quite daunting. But it is quite procedural driven actually. So if we can just break that down and briefly go through the procedure, what we're doing, what it all means, and how you can input to that as well, that's probably quite helpful. So this process here, this legal life cycle, which I've broken down here, can take anywhere, say, between 4 and 12 months typically. You know, we've had to do them shorter in the past, we've had them go on longer. So it just depends on a lot of things. It depends on how well that first stage goes. It depends on the intention of the parties and how driven sometimes people are to achieve the end goal, and how well the business is actually performing if the business is being transferred at the same time. You know, we have had transactions which have been delayed because of performance, and they've been put on hold and picked up, say, a few months later once performance has improved. So we have had that scenario as well. So it's always difficult to estimate how long these things are going to take. There's a visual here to just break down and show that legal process. So each party will instruct their own legal team. And these type of transactions are likely to involve 3 sets of lawyers. So you'll have the buyer and seller instructing their own legal team. You'll also often have the bank's lawyers, if you're having funding for this type of transaction, often instructing their own legal team as well. So we're often already dealing with 3 sets of lawyers, which can take its time. And also, if you've got a lease in the transaction, there may be another set of lawyers acting for landlord as well. So we're often dealing with multi-parties in these type of transactions, and typically the more parties you have, the longer things are going to take to get things agreed. So that's just something to bear in mind. And like I said, it's useful to have all lawyers' details at the outset so things can get moving in all directions when they need to. We may even, in each legal team, we may need additional specialist lawyers involved, as well as corporate and property with myself and James and our teams. We are also likely to need involvement perhaps from the employment team, particularly if we've got an asset deal, and needing 2P advice. We may need input from the charities team, regulatory team, construction team if it's a new build. And we'll also liaise with the rest of your professional team, whether that be accountant, surveyor, broker, funder, whoever that may be. So yeah, so just taking you through these stages briefly. We'll have the legal due diligence stage. So you may have collected some financial due diligence and practical due diligence at the outset. We then have the legal due diligence, and a data room is usually set up by the seller's lawyer to deal with all of this. The information is all collated there. So all that information you've collected as that first stage can go into the data room and you can be prepared there. And this is usually the stage actually that takes the longest, because there's usually a lot of information that goes in there, both on the property and corporate side. There'll be standard inquiries that are raised that need to be answered. That all goes in there as well. And on the next slide in a moment, we'll look through the corporate and property aspect of that. We'll then have the transactional document, which the legal documents to be agreed between the lawyers, both property and corporate. Once all that's sorted and agreed, we then have exchange of contracts, and that's when the transaction becomes legally binding. And I always compare the process to buying a house, although obviously this process is a bit more involved and intricate than buying a house. But this is where things become legally binding and parties can't walk away without implications. So until we actually get to exchange of contracts, either party can change their mind and walk away, which is really frustrating, which is why we have the cost contribution and things like that covered in heads of terms to try and protect those scenarios as much as we can, because obviously, unlike buying a house, things are a bit more involved. A lot more money's been expended before we get to this stage. And these are things that just need to be thought about and covered to mitigate those risks, really. So that's when things become legally binding. We may have a gap between exchange and completion. We'll have completion itself. This is when the legal documents are completed and the ownership of the premises and the business is transferred. And then once we get to completion, post-completion, the story doesn't stop there, particularly for us lawyers, where there'll be things for us to do post-completion as well, which may involve registration requirements, dealing with bundles and other post-completion obligations as well. So that is a very brief canter through the legal process and each relevant stage. And then on the next slides, we'll start to look at breaking that down into the corporate and the property aspects.
Yep, so from a corporate perspective, once obviously your due diligence is completed, we've got a set of replies, we've got documents, as Lisa referred to, in the data room. We can then look to prepare. So if you're buyer's solicitor would usually take the lead on this. So having regard to the information that the seller's provided, start to prepare either an asset purchase agreement or a share purchase agreement. Within those documents, we set out clearly, again, who the parties are, what the purchase price is, set out a list of liabilities and warranties and indemnities for those liabilities, unless the parties were able to negotiate some way around that prior to the drafting. Set out exactly what a purchaser is buying, so setting out the staff, the employees, the assets, so the equipment, make sure that all that information is in there and recorded correctly. In addition, you'll have ancillary documents. So again, if you're purchasing as a limited company, if you're purchasing shares, obviously you'll have the ancillary documents such as sort of transfer forms. You'll have board minutes, potentially even service agreements, directors' service agreements. Especially if you're purchasing a company that has particular intellectual property rights. Do those intellectual property rights actually come with the company, or are they separate? So would you need an IP licensing agreement? So those are some of the documents to consider at that stage. Again, as Lisa stated, bank and finance. Usually a bank will instruct its own solicitors. They will send off documents, so they the bank may look to take a charge over the company or over the property, which I think that Lisa will touch on the next slide. But typically banks will want to take out a debenture or a cross guarantee if there's more than one company, to secure their finance. That will typically be over the assets, the equipment, including the shares in the company if you're purchasing shares. And then we get to exchange and completion. So that will typically look like it could be a simultaneous exchange and completion. So we'll exchange and complete on the same day, or if there are certain things that need to be put into place. So for example, you're waiting for the CQC letter to come through. That may take a couple of weeks, in which case you could exchange. It's a bit of a risk between exchange and completion, but as Lisa said, that then locks the parties into the deal, which is pretty difficult to get out of. Looking at post-completion, again, post-completion could be looking at stamp duty that's payable on shares of a company, so you need to ensure that that's paid. Ensuring that charges are registered at a company's house. I believe that the period for that is 30 days. Making sure that you've got your insurance in place. So again, we touched upon employers' liability insurance, public liability insurance, and also looking at deferred consideration, which is a slide we'll come on to a little bit later. Lisa.
Yes, so on the property side, I won't go into this into too much detail, but just to look at some of the things here. So the property legal due diligence will involve us carrying out our standard property searches, which the lender will require anyway, looking at title, any issues, defects with title or restrictions on title which we need to address. We have standard inquiries, replies to CPSC, which need to be looked at and raised. Statutory compliance documents, so that's the regulatory documents we talked about with the fire risk assessments, asbestos, those type of things we discussed earlier, and we'll be checking for remedial actions, making sure that's been carried out. Has the property got the necessary planning consents and building regulation consents? We need to look into all of that. So there's a lot of legal property due diligence which needs to take place and take time. Searches take time to come back, so that process does take a good number of weeks to go through. And then there's transactional documents itself. So on the property side, if we've got an asset, if we've got a share deal, then nice and easy. We don't have the property documents other than any warranties and indemnities in the share transfer agreement. But if it's an asset deal, there may be a separate contract, there may be a transfer deed which transfers the legal title, and will also be inputted into the corporate documents there as well. So looking at the sale agreement, any disclosure letter, dealing with any legal charge on behalf of any lender and advising the client on what that means for them, and dealing with any third party consents as well. So that's transactional documents on the property side. We'll do a report on title. So we'll review all of that, summarise all of that for you in a nice, neat product that you can take away, and advise you on any issues which need to be addressed, either practically speaking or in the legal documentation, what it all means. And then you can obviously let us know if you've got any questions on any of that. There may be a separate report and title needed on the bank side as well, so that will need to tie in, and we'll have to work with the bank's lawyers on any issues arising out of that. We'll then have exchange completion. Quite typically with these transactions, actually we do have a gap between exchange completion. Particularly a lot of our clients, particularly on the buy side, like that gap actually, so they can start the integration of the businesses, they can meet the teams if need be, and they can deal with the more practical aspects, any third-party consents that are needed, things like that. So everyone's always keen to get things exchanged as soon as possible, before, once all the due diligence and everything's all carried out. But sometimes they just need that breathing space before completion to sort some of the practicalities out. And on the post-completion side on property, again, depending on whether it's an asset or share deal, but if it's an asset deal, we may have SDLT that we need to deal with and land registration at the land registry to make everything legally binding. And that process can take a very long time at the moment. I think we're on 2 years at the minute, which is really frustrating for us property lawyers, because we end up with lots and lots of live active files because we can't close anything until the registration process has completed. So as you can imagine, I think a good, at least a good half of all our files are all waiting for land registration, which is very, very frustrating. So don't worry if you don't hear from your lawyers a good 2 years after completion with confirmation everything's been registered, because it's just an unfortunate part of the process at the moment. I'm conscious of time, so let's have a bit of a canter through the next slides. The next slide, I just wanted to give a bit of a visual because it looked nice, and also just to make it clear that this is the point that we all build up to legal completion. Keys are handed over, you start running the business, and it's all very exciting. And I had a client actually ask me a couple of days ago, it was 4:30, and they said to me, Lisa, can completion take place after 5 o'clock, or is that our cut-off time? Just to make it clear, completion can take place any time, and often with these type of deals they generally do take place in the evenings, not because we want them to, it's because there's so much that needs to be done on the lead up to completion, on the day of completion, with agreeing completion statements, doing any pre-completion searches, getting any last minute consents, all that type of thing that can't be done till the last day, which often takes us up until later in the day. And as lawyers, and actually as clients and all other advisors on the deal as well, you want it done that day, because if it slips into the next day, you've then got new apportionments to deal with, new searches that need to be, completion searches that need to be undertaken. And it's very frustrating. So that's often why deals do happen in the evening, unfortunately. It's to make sure it all works and everything comes together and you don't have to repeat it all again the next day. So yes, we often do completions after 5 o'clock. Even if money isn't where it needs to be these days, we deal with a lot of things by completion undertakings. So it's not an issue as long as funders have released the money. That's the qualification I will give there, because obviously we need that money to complete in the first place. So that just quickly on there. And then post legals, then, like I said, the story doesn't often end there. There's some other things to think about. There's a lot of information and bits and pieces on the slides here, but if we have a quick run through some of these things to think about post completion, then I think we've got deferred consideration next. Yeah.
So I think very briefly, because of time, so really to summarise what deferred consideration and out provisions are and do, it's really a useful way of bridging the gap between a buyer and a seller in relation to obviously the consideration, the amount payable, and it can certainly with earn-out provisions incentivise a seller. It also provides comfort to a buyer with the knowledge that the business that you've acquired will continue to grow. It should be noted, though, that both deferred consideration and earn-outs can be complex. So there are tax considerations there, especially when you're buying a company. What are likely going to be the most negotiated part of any transaction. So in light of the complexity and tax implications, it's really vital that your solicitor and indeed your accountant as well, who will also need input on these provisions, work in collaboration with each other. Otherwise, you could underpay tax on the consideration, or the other implication is that a seller may, for whatever reason, not become entitled to a payment because of misdrafting in the wording, which has happened. I've come across a couple of examples in that instance, which could lead to litigation, which again could be costly and time consuming.
And next. Yeah, so this is, I think we've touched on a lot of this as well, future involvement with the business, just have a think about where and where you might want to be involved in the business going forward, any consultancy arrangements with them, with the sellers, any restrictive covenants preventing you from working within a certain distance of the property, things like that. But that, I think we discussed that briefly in the heads of terms stage, so we won't go into too much detail there. If I can just go on to the next slide, which is overage, because we haven't really mentioned this, and I probably could do a session on its own actually on overage, but just to plant the seed and something to think about. Overage is generally used to describe the situation where the seller is to share in any future increase in value once the property is sold. So it's a great mechanism sometimes for buyers actually and sellers, and often used with care homes and social care premises, where there's an expectation that they could be planning in the future, or could be some extension and quite substantial increase in value in the future as well. So just something to think about. And like I said, I might do a follow-up session or at least an article or something on overage, because it is very complex, which is why people do shy away from it, because the drafting is very complex and there's lots of different things to think about, different triggers for the overage when it becomes payable, how it's going to be paid, how it's going to be secured on the property. So yes, it is very complicated, and actually there may be other more suitable ways of dealing with the situation. So we may have a conditional contract, which is conditional on planning, which is a lot more straightforward and more common, or you might have a restrictive covenant over the property saying it can't be used for a particular use, and obviously if the buyer wants to use it for that use in the future, they'll have to buy out of that covenant. So that's sometimes used in that way as well. So just wanted to plant the seed at this stage with overage, something to think about, not to be scared of, to take advice on it and consider options. And I will do something separately on overage in the future. But what I really wanted to end with is our top tips. So challenged both myself and James in coming up with 3 things which we wanted you to take away today. So my property top tips are on the left hand side and James's top tips are there on the right hand side. We've covered a lot of it, and I think when I was thinking about my 3, I wanted to make sure I covered some points here which have an impact both on time and expense, which is obviously the things people are concerned about. So from my point of view, understand the property position, that's in terms of freehold, leasehold, any consents needed, whether VAT is payable, that's really key. Dilapidations, obtain your survey, understand what we're dealing with and whether we need to have any discussions regarding revisiting the purchase price. And my final one is that it pays dividends to instruct experienced advisors, lawyers, brokers, funders, whoever it is. You need people who really know what they're doing to guide you through this process.
I think my 3 really cover obviously the fundamental terms, understand what it is that you're purchasing, get those key terms really hashed out in the heads of terms so everyone is on the same page right from the beginning. Understand obviously the benefits and the liabilities that you'll be taking on or disposing of, how that is effectively going to affect you now and in the future, so you can account for those scenarios. And really finally, to manage your time, as Lisa has said, this usually isn't a quick process. There's a lot of things to consider in a transaction such as this. Regulations, you've got finance, CQC, due diligence, and things may come out of the woodwork. So being able to manage your time, apportion it appropriately to each stage is really, really key.
Fabulous. And that is the end of our presentation. Do email either myself or James with any questions, and we will be more than happy. We're delighted to assist and answer any questions you have. And we also have our follow-up sessions as well over the next 2 Wednesdays on charities and employment issues. There are our details there. So our email details and contact details are on the end of the slides there for anyone who may need them. Thank you very much.